5 seconds to go. Start. Frivolity in prosecution should always be considered, and it is only the element of genuineness that shall have to be considered in the matter of grant of bail, and in the event of there being some doubt as to the genuineness of the prosecution in the normal course of events, the accused is entitled to an order of bail. In yet another recent Constitution bench judgment in the case of Sushila Agarwal and others versus State and City of Delhi and another, in paragraph 85 of the report, Justice laid down the guiding principles in dealing with applications under section 438. This court, in the light of the above discussion in the two judgments and in the light of the answers to the reference, hereby clarifies that the following need to be kept in mind by courts dealing with applications under section 438 CRPC. Consistent with the judgment in Shri Gurbaksh Singh and others versus State of Punjab, when a person complains of apprehension of arrest and approaches for order, the application should be based on concrete facts and not vague or general allegations relatable to one or other specific offence. The application seeking anticipatory bail should contain bare essential facts relating to the offence and why the applicant reasonably apprehends arrest, as well as his side of the story. These are essential for the court, which should consider his application to evaluate the threat or apprehension, its gravity or seriousness, and the appropriateness of any condition that may have to be imposed. It is not essential that an application should be moved only after an FIR is filed. It can be moved earlier so long as the facts are clear and there is reasonable basis for apprehending arrest. It may be advisable for the court, which is approached with an application under section 438, depending on the seriousness of the threat of arrest, to issue notice to the public prosecutor and obtain facts even while granting limited interim anticipatory bail. Nothing in section 438 CRPC compels or obliges courts to impose conditions limiting relief in terms of time or upon filing of FIR or recording of statement of any witness by the police during investigation or inquiry, etc. While considering an application for grant of anticipatory bail, the court has to consider the nature of the offence, the role of the person, the likelihood of his influencing the course of investigation or tampering with evidence, including intimidating witnesses, likelihood of fleeing justice, such as leaving the country, etc. The courts would be justified and ought to impose conditions spelt out in section 437(3) CRPC by virtue of section 438(2). The need to impose other restrictive conditions would have to be judged on a case-by-case basis and depending upon the materials produced by the state or the investigating agency. Such special or other restrictive conditions may be imposed if the case or cases warrant, but should not be imposed in a routine manner in all cases. Stop.